Ladies and gentlemen, good morning from Bratislava and a warm welcome to today's webinar, Challenges Post-Corona for Entrepreneurs. In the upcoming hour, we would like to give you insights on how to safeguard your company when your business partners are in trouble and which liabilities you absolutely need to be aware of as a manager of an Austrian subsidiary in Slovakia. Let me introduce today's speakers. Christian Kugel is the head of Advantage Austria Bratislava. He will give you a short summary on the last remaining travel restrictions that we have at the moment between Austria and Slovakia. And our headliner today, so to say, is Martin Jacko. He is attorney at law and managing partner of Lansky, Ganska and Partner in Bratislava. Now, the Austrians among you are, I'm sure, familiar with the law firm Lansky. However, they are not only a leading law firm in Austria, in Vienna, but also in all of Central Europe, with their offices in Vienna, in Bratislava, in Nur-Sultan, in Kazakhstan, and also in Skopje. So, Mr. Jacko, we are very thankful that you have agreed to give this briefing to the Austrian community in Slovakia today. It is my pleasure to be your host at today's webinar. My name is Cornelia Reibach-Stambolia, and I'm the Deputy Head of Advantage Austria Bratislava. Of course, you're also welcome to send us your questions by email after the webinar. And needless to say, both our speakers, Martin Jacko and Christian Kugel, are available for individual consultation after the webinar. Christian Kugel and I would be particularly happy if you joined us on the Exporttag 2021. The Day of Export is our annual flagship event and is one of the biggest events that is organized in the Austrian Federal Economic Chamber in Vienna. This year's edition is going to take place on the 29th and 30th of June. We've decided to play it safe and to have another online edition, but that's an advantage for you because at your fingertip from your office, from your home office, you can book one-on-one meetings with heads of Advantage Austria offices all around the world. So no matter which market you're interested in, if it's Central Europe, if it's Southeast Europe, or maybe Southeast Asia, the commercial counselors are at your disposal for individual consultations. And needless to say, we will also have very interesting keynote speeches about economic trends and up-and-coming markets. So now the timeline for today's webinar. Christian Kugel will start with an update on the COVID-related travel restrictions in Slovakia and Austria. And then at 11 and 10 minutes, Martin Jacko will start his presentation on the challenges post-corona for entrepreneurs. At approximately 11:40, we will start the Q&A session, which will go on until 12 approximately. So now, without further ado, I would like to give the virtual floor to Christian Kugel, the head of Advantage Austria Bratislava. Christian, the floor is yours.
Thank you, Cornelia. Welcome, ladies and gentlemen, to our webinar today. And thank you, Martin Jacko and Lansky, Ganska and Partners, to take part in this event today. I would like to update you on the traveling restrictions related to COVID briefly. First slide you see is when you come from Austria to Slovakia, what to expect at the border. Austria, as the Czech Republic, Hungary and Poland are neighbors of Slovakia in the so-called green zone. So if you are vaccinated or recovered from COVID within the last 180 days, or if you arrive with a negative antigen test no older than 1 day, you may enter Slovakia without quarantine. You still have to register at the electronic site e-Granica, and for all of this group, the registration is necessary. There are many exceptions of these rules, especially for commuters. They do not need to register. They can enter with a negative PCR or antigen test no older than 7 days, or a confirmation about their vaccination or recovery from COVID. As for the entry as a commuter, you need a confirmation of your employer, and you have to live and work within 100 kilometers from the border. If you come from Slovakia, there's no kilometer limit in this connection. Just to let you know, if in Slovakia the mobile test stations, that we are used to for the last months, they will most of them will cease to exist by end of this month, and then there will be other test stations, but not all of these MOMs will still be there. So the other way around, traveling from Slovakia to Austria. Slovakia is for Austria on the A list as a safe country. And you may enter from Slovakia to Austria without quarantine if you fulfill one of the 3G rules. If you're either vaccinated or recovered from COVID within the last 180 days, or you have a negative COVID test, PCR test max 3 days old, antigen test max 2 days old, then you may enter. You don't need to register, and not anymore. The pre-travel registration is not used right now, and you don't need to prove the reason for your travel any longer. Commuters either need to be vaccinated or recovered or measure a negative test no older than 1 week. Again, no travel registration required. So back to you, Cornelia.
Thank you so much, Christian, for these good news. I think everybody agrees that it is a relief to hear how easy traveling from Austria to Slovakia is now. If I think back only 2 months ago, I think about half of the inquiries that we got in our office were related to how can I travel to Slovakia, how can I travel back to Austria. So it is absolutely good news that the restrictions were considerably eased in the last couple of weeks. So Christian, before we give the floor to our headliner, so to say, Martin Jacko, I would like to ask you, what is your impression of the current economic situation in Slovakia? Do you see a recovery, and what are your expectations for the months to come?
The macroeconomic data for Slovakia are actually better than expected months ago. The Economist estimates a growth rate of the gross domestic product for this year of about 4.4%, and matching the loss of last year of about 5.2% to a large extent. Main reason for this development is the industry, who actually was quite stable and was actually able to retain most of its employees. The service sectors, as in any other countries, suffered most, and I actually sense a reluctancy of the consumers to spend their money. The savings rate is actually too high. The economic crisis over the last through the pandemic was actually as steep as the economic crisis in 2008-2009, but it's going back up much faster. So it won't take that long to compensate for the losses. So everything happened in the last 1 year much faster than 12 years ago. So far, it doesn't look that we face an immediate danger for a larger inflation. A temporary inflation might reach about 2.5%, and that is similar to Austria actually. The unemployment rate is now between 6 and 7%, according to different data. So the outlooks are not bad. It's similar in Austria, but all this depends on that we can keep Corona in check, that people get vaccinated, and we do not face a problem in fall. Thank you.
Thank you so much, Christian. And on this positive note, I would now like to hand over to Martin Jacko, Managing Partner at Lansky, Ganska and Partner Bratislava. Mr. Jacko will now give us his presentation on the economic difficulties and challenges of entrepreneurs in these times after Corona, or where Corona gives us a break, to put it like that. So, Mr. Jacko, the floor is yours.
Thank you very much. Good morning to everybody. I'm very happy that I have this opportunity to present the respective topic. As said, I am attorney at law and managing partner of Lansky Ganska Partner. Also, I have a position of insolvency and restructuring administrator, so-called Masseverwalter. So I have a very close relationship to the topic which should be discussed. Main topics which we would like to touch in our short presentation are pandemic and its impacts to the business environment, then also caused economic difficulties of entrepreneurs, obligations in case of entrepreneurs in crisis, then also obligations in case of indebtedness of entrepreneur, then relating liabilities of statutory body and controlling person, impacts on contractual relationships, informal and formal possibilities of solving of the economic difficulties, and also some maybe little advantages of the pandemic, if we can say like that. And then, of course, there will be a space for questions. In generally, in Slovakia, as also in other countries, this pandemic situation is unprecedented in recent decades. Entrepreneurs in many segments could not carry out their businesses at all, or some could do it only under the significantly reduced rates. The result are extensive damage in these segments, but even worse, there has been also segments which would not be touched by the pandemic. However, as a secondary impact or effect, there are also damages and big problems caused also in these segments. Slovakia is no exception. Well, as we can see, the situation is a little bit improving. However, the impacts remains. I would say that the most significant impacts are on contractual relationships with business partner and third parties of the entrepreneur. Most presented are definitely delays and non-fulfillment of obligations, including the financial obligations, of course, resulting from the contract. And then also, as a result, activation of related contractual instruments, which are mostly interest on late payments, contractual penalties, and seeking for liquidated damages. We have to say, as already mentioned, that even the healthy entrepreneurs who are not directly touched by the pandemic situation were also influenced in a very high volume due to the secondary insolvency. I'm sorry, and as an impact of the directly attacked entrepreneurs. Other fact or other seen fact and a result of the pandemic situation is also rising of some commodity prices and extension of delivery periods. We can see that, for instance, in our own practice, where in the construction business, where we represent many of our clients, there are very serious lack of commodities like wood or steel, and this causes enormous increase of the prices. In many cases, 50+%, and of course also delays in deliveries. Having this in mind, the entrepreneurs are suffering the economic difficulties. With regard to economic difficulties, it is necessary to also assess whether the entrepreneur is bankrupted or not. In order to understand what the bankruptcy means in the Slovak law system, we need to distinguish between two forms of bankruptcy. There is a insolvency. This is the first form of a bankruptcy, and an entrepreneur is in the situation of insolvency when is not able to fulfill 30 days after the maturity period at least 2 financial obligations to more than one creditor. And these financial obligations are not covered by his financial assets. The financial assets, we understand monetary assets, monetary means, and also receivables from bank accounts or deposits, also monetary receivables which are of maturity, which expires within 30 days, and also monetary receivables that are due on demand on site. So this is the financial asset which should be covering these obligations. Then we have the second form of bankruptcy, and it's indebtedness. Indebtedness is a situation where entrepreneur has more than one creditor and the value of its debts exceeded the value of its equity. You have to also bear in mind that in this calculation, we do not calculate the debts towards affiliated persons. This is very important because in many cases there are several obligations towards the affiliated persons. In connection with the bankruptcy as defined in the previous slide and imminentness of bankruptcies, there is an institute of crisis or entrepreneur in crisis. Such entrepreneur in crisis has in the situation where is bankrupted or there is imminentness of bankruptcy, has several obligations. When we are talking about entrepreneur, this applies to limited liability company, joint stock company, simple shares company, and limited partnership, Kommanditgesellschaft. It does not apply to natural persons. The main situation or main definition is that the entrepreneurs is in the imminentness of bankruptcy when its own assets, that means own financial resources, comparing to its liabilities, meaning external financing resources, are less than 8 to 100. So this is the situation when the bankruptcy is imminent. So the crisis applies, or provisions concerning crisis applies either when the entrepreneur is already in bankruptcy or there is imminentness of bankruptcy, mentioned ratio 8 to 100. From the perspective of entrepreneur and his statutory body, it is very important that statutory body regularly, on a regular basis, and with professional diligence, monitors the entrepreneur's financial statements and financial situation, and thus would be able to distinguish between the situation, whether there is imminentness of bankruptcy or not, or maybe even if there is already bankruptcy. In both cases, the statutory body is obliged to take all the possible measures to prevent or to remedy the crisis. There are several actions which could be taken. One of that would be a repayment of monetary liabilities that are more than 30 days after the due date before the end of the year. There is also a very significant obligation to with regards to benefits from shareholders, statutory bodies, and affiliated parties. The situation where the bankruptcy is only imminent is not linked to the imminent threat of bankruptcy or restructuring proceedings, but it's linked to following legal consequences. As mentioned, all benefits, either from shareholders, statutory bodies, or affiliated parties received by this entrepreneur in crisis cannot be reimbursed to them before the entrepreneur has recovered from the crisis. If the entrepreneur, in breach of this prohibition, returns a performance, replacing its own resources, that's terminus technicus, but as an example, it could be shareholder loan, such performance must be returned to the entrepreneur and to statutory body. And to statutory body which should recover this performance. We are moving further to obligations of statutory body concerning or in the situation of indebtedness of entrepreneur. According to the Slovak law, just to shortly repeat it, there is a parameter of indebtedness is that the value of entrepreneur's debts exceed the value of its equity. In such a situation, the indebted entrepreneur shall be obliged to file a petition for bankruptcy within 30 days after it either becomes aware or with respect to his obligations to act in due care may have become aware of his indebtedness. Such obligation bounds entrepreneur, but also the statutory body or any member of the statutory body of the entrepreneur. In case that there is a breach of such a duty to file the petition for bankruptcy in due time, within 30 days, the legislation counts with a sanction. This sanction is being imposed to obliged person, and the amount corresponds with half of the minimum share capital of the joint stock company, which is currently 12,500 euro. This sanction will be later on in the, or would be later on in the insolvency seeking by insolvency trustee, insolvency administrator, and it becomes part of the bankruptcy assets, which will be further distributed to the creditors. It is very important also to mention that in the same time, if there is a breach of such obligation to file the petition for bankruptcy, a statutory body may also carry a criminal liability. The criminal code has provision concerning criminal offense of obstructing bankruptcy and settlement proceedings, and that could be committed also by a person who does not file a petition in bankruptcy in due time. So seeing this, there is a big danger of becoming liable also in the criminal perspective for the statutory body. There are maybe some recommendations which should the statutory body follow, and I would list or mention maybe some more obligations. So irrespective to the fact whether there are economical difficulties or there is a normal operation, statutory body is always obliged to execute its competencies with professional care and always in accordance with the interests of the entrepreneur and all of its shareholders. This is very important. In particular, statutory body is obliged to obtain and take into account in their decisions making process all available information. That means in these cases, all available information, including the market, the impact of the pandemic situation, and take it into account in decisions concerning the company and leading of the company. Also, one has not cannot forget about obligations to keep in confidence the confidential information and facts about the entrepreneur, which could endanger the interest of the company, of the entrepreneur or its shareholders. And of course, the obligation that statutory body must not give a priority to their own interests, but also to interests of certain shareholders or third parties, of course. In case that there is a breach of such obligation by the statutory body, the statutory body members are obliged jointly and severally to compensate the damage caused to the entrepreneur by such activities. Statutory body shall not bear liability for damages if they can prove that there has been exercising of their competencies and powers with due care and in good faith. Acting with the interests of entrepreneurs, which they obviously has to know. There is also other possibility, and it is that executive officers also shall not bear the liability for any damage caused when they were conducting, when their conduct in executing a decision of a general assembly. So this is another case where they can liberate from the liability to pay the compensations. I have to also say that any agreements between the companies and its executive officers that exclude or limit the executive officer's liability are prohibited by the Slovak law. We continue further to liabilities of statutory body. It is important also to mention that the entrepreneur is part of the contractual relationships and obligations. So each statutory body, of course, should ensure that it complies with obligations rising from these contractual relationships, but also in connection with economical difficulties, what we are just discussing. So there could be several obligations resulting from contracts. For instance, notify about the current situation, current financial situations, or not ability to follow and perform the obligations according to a contract. There are, from my practice, many contractual obligations, especially with banks or insurance companies, or maybe also companies providing leasing services. Failing to follow these obligations can trigger, of course, a liability and then later on penalties, which, if not done with due care by statutory body, could be also contributed to such a statutory body. Also, very important obligation is obligation of statutory body to exclude contestable or avoidable legal acts if entrepreneur is bankrupt. In particular, it could be acts without adequate consideration or acts which are giving some preferential treatment to a creditor or curtailing the creditors. This is very important legal consequences. Such acts can be later invalid, and then compensation can be requested, and in in potential insolvency proceedings definitely will be done by the insolvency administrator. As mentioned previously, there is also a criminal liability which has to be taken into account from the perspective of statutory body, but not only that, but also from perspective of a company or entrepreneur. There are several criminal offenses which could be committed by entrepreneur or statutory body. One of the most common in economical difficulties is non-payment of wages and severances. The provision says that whoever, as a statutory body of a legal entity, fails to pay their employees' wages or other remunerations for work, which the employee is entitled on the date of its maturity, although on that day they had monetary means for their payment that they did not necessarily need to ensure, can cause and commit such a criminal offense. Then another criminal offense, which is possible in this perspective, what we are discussing today, is caused bankruptcy. This is a case when a statutory body causes a bankruptcy of legal entity and obstructs the satisfaction of creditors' receivables, at least in the amount of 2,660 euro, which is very low volume, and it could be achieved very easily. Then we have also the criminal offense of violations of obligations of trust. There is also this potential situation when statutory body can commit this crime, and then also favoring of a creditor. Sorry, that's the case where a creditor is one creditor is treated in a better way as far as satisfaction than the other ones. And last but not least, it's a failure to pay taxes and insurance. So except the criminal offense of non-payment of wages and severance, all these criminal offenses could be also committed by a legal person. So that means it could trigger the liability of entrepreneur as a legal entity. And in a worst case scenario, well, there could be imposed a fine, penalty, but in worst case scenario, a ban of activity or cancellation of legal entity. In the same time, we have to say that there are also obligations concerning the controlling persons. A controlling person, let's say mother company or holding company, could be also liable to the creditors of controlled person for damage caused by the bankruptcy of such a controlled person. However, only provided that the controlling person activity considerably contributed to the bankruptcy of such a controlled person. There is a controlled person is a company in which the controlling person has a majority share in the voting rights, and the controlling person shall be released from such a liability only if such a person proves that acts in an informed manner and in good faith, that they were acting for the benefit of the controlled persons. Sometimes it's difficult to distinguish between that because there are many cases where it really depends on interpretation and evaluation of the transactions in connection with the other ones as well. Coming to the impacts on contractual relationships, as already said, the economical difficulties of entrepreneur have serious impact also on his contractual relationships. Delay is the most common situation connected to the pandemic situation. And in such a cases, mostly other contractual party activates interest on late payments. It could be either contractual or calculated according to the law. Then definitely there could be also other agreed contractual penalties within the contractual relationships. Compensations for cost damages is also a very significant obligation which could arise from non-performance. And the most critical is, of course, withdrawal from the contract. Usually it happens when the delay constitutes a fundamental breach of the contract. Failure to fulfill contractual obligations due to pandemic can be considered as circumstances of force majeure, frustration of purpose of the contract, and impossibility of performance of the contract. It is important to mention, due to fact that it could be used also in order to liberate the entrepreneur from a violation of his legal obligations. The force majeure or vis major is institute which allows the liable party to release from its liability for damages caused when they prove that the breach to fulfill the obligations was caused by such a situation. There are several features which must be met in order to say that there has been a vis major. As mentioned on this slide, so independence of the will of contractual party hindered to performance the duty, it must be unavoidable, unpredictable, and it must occur before the delay of the obliged party and not originated in the economical circumstances. Pandemic, from a certain perspective, could be a reason and could fulfill the conditions and to become a force majeure or vis major, and could, let's say, help to liberate from the obligations. There are, however, several contractual conditions which could stipulate the either definitions of vis major or the relationships and applying of impacts and consequences of vis major differently. For instance, again, I will mention the construction law. There are, for instance, in so-called FIDIC contracts, there are contractual conditions which are having its own process of notifying of the vis major and having own, let's say, consequences, and this needs to be paid attention in a very serious way in applying these special contractual relationships. Then also a frustration of purpose of the contract. That's the situation when the basic purpose of the contract, which is explicitly expressed in the contract, is frustrated after its conclusion in consequence of fundamental change of the circumstances, which could be also a pandemic under certain cases, and it caused that party affected by the frustration of the purpose may withdraw from the contract as such. In this connection, it is necessary to assess the specifics of the case, whether such a change of circumstances is based on a pandemic or not. However, such a change of circumstances shall not be deemed a change in the property relationship of either of the parties or change in the economic or market situation. Important is that the party that withdrew the contract is obliged to compensate the other party for damages they incurred by the withdrawal from the contract. Another case is impossibility of the performance of the contract. If the performance of the contract becomes impossible, then the debtor obligations to perform shall extinct. However, the performance shall not be deemed impossible, in particular if it may also be provided under aggravated conditions or with larger expenses or after the agreed time. So this also needs to be paid attention to. The party shall be obliged to notify the other party without undue delay about such circumstances, otherwise there will be liability for cost damages. So we are coming to the possibilities to solve the economical difficulties. Basically, we can say that there are several advantages and disadvantages. When we are talking about informal instruments, we are talking about instruments as timely communication with the creditors, especially banks, insurance companies, tax authorities, trying to negotiate also maybe installments and some payment plan. This is very important and can help to prevent the more critical situation. there are also maybe possibilities or ideas to search for some investors who can help out to overcome the situation, or to do some informal restructuring. There are several options with regards to also discussions with the bank to make a standstill, some haircuts. The advantages, of course, is a saving of time. It is an informal process, and that means that if you are successful in negotiation with your contractual partners, you can really prevent many administrative formalities and demands. Once it is not public, it should have either no effect or lower effect on the reputation of the entrepreneur, which is also a big advantage. And results supposed to be continuing and carrying continuing business without any special effects and impacts, without need to fulfill some additional obligations. As far as the formal possibilities of solving, we are talking about temporary protection of entrepreneurs in financial difficulties, restructuring, and then bankruptcy. I will go very quickly through that due to the time pressure. So temporary protection of entrepreneurs in financial difficulties is a new institute which should enable the entrepreneurs to continue with their businesses even when they have financial difficulties, prevent job losses, losses of know-how, and lead to higher satisfaction of creditors' receivables. Shortly, the conditions: the entrepreneur should have the center of its interest in Slovakia, could not be bank, insurance company, or broker. Then there must be a decision of absolute majority of creditors about using this institute. There is also no ground for its termination or bankruptcy effects or restructuring permits. No enforcement proceedings is pending against the applicant. No exercise of pledge was not commenced, and must be registered in the public sector partners. The effects, this is very important, are passive bankruptcy immunity. That means that it is not possible to decide about opening of bankruptcy procedure. Then also active bankruptcy immunity. It means that in case of indebtedness, the entrepreneur is not obliged to file a petition for bankruptcy. Then all the enforcement proceedings are interrupted. Pledge cannot be exercised against such an entity, and it is also not possible to set off receivables towards the entrepreneur. These are the main consequences. It could be a grant for 3 months and then extension for another 3 months. However, there is a necessity to have a 2/3 of majority of creditors agreement with such a prolongation. The primary goal is, of course, to avoid financial difficulties and bankruptcy. If this financial temporary protection does not help, then there is also a way of restructuring, or so-called Chapter 11 procedure, which is a formal process. The main conditions are that there must be satisfaction of unsecured creditors of at least 50%, and there must be a chance to preserve at least a substantial part of business of the entrepreneur. Upon meeting these conditions, there is a possibility to start the process of restructuring and create a restructuring plan, have it agreed by the majority of the creditors, and then to follow it and thus to get rid of the debts up to 50%, as mentioned. Then I would say final formal procedure or process is the bankruptcy. As mentioned, there is a legal obligation to file petition for bankruptcy within 30 days after becoming aware of indebtedness. under the fine of 12,500 euro. It is very important to mention that even when the entrepreneur goes to bankruptcy, there are several obligations which must be fulfilled in order to properly file a petition, list of property, a list of obligations, list of affiliated persons, list of contracts, list of contestable acts must be provided, including financial documentation. Once provided in a proper way, then it could avoid some liability of statutory body. It is also necessary to understand that there is necessity to do research or verification of possible contestable legal acts, because that's one of the obligation to mention such acts which could be potentially contested by a trustee. And there are serious legal consequences, as mentioned earlier. Invalidity of such legal actions and compensations will be requested. The main focus, of course, is to sell all the properties, all the assets, and collect the financial funds, and then distribute that to the registered creditors. There are also, well, we can say advantages which were brought by the pandemic, or maybe acceleration of certain other institutes. Just very briefly, home office, or according to the Slovak Labor Code, work from home, has been also significantly changed in the recent period in order to meet the situation, conditions, requirements. So there was a labor code change in order to reflect all this. There are many obligations and rights also of the employers. It is that would be for one webinar, definitely. Then distance signing. I would say that Corona crisis or pandemic definitely accelerates also communication, electronic communication, including the business partners, but also with the authorities. So we are talking about using of the ZEP or CAP and QoS ES certifications. It also has, however, some challenges, and it needs to be set up properly and chosen properly in order to avoid some potential problems and risks which could arise from communication in electronic environment. Also, organizing of company bodies. There was a huge demand to adopt decisions per rollam. So remote voting of the members of company bodies, decision making is also possible. We strongly recommend to make some amendments of the statutes or articles of association in order to serve the purpose. And also in GDPR, it must be said that this part becomes also very important and helped out a little bit to improve it. But I think that all the companies which have the proper GDPR setup have easily gone through this also challenge with regard to the personal data and its using and keeping. So that would be from my side. I'm sorry that I took like 9 minutes more. Looking forward to questions.
No problem at all, Mr. Jacko. Thank you so much for summing up this very complex matter. And now, of course, we look forward to taking your questions, to answering or to give you recommendations how to treat your individual challenges. So, for example, have you had impact of the pandemic on contracts? Could they maybe not be fulfilled, or do some of your business partners currently have economic difficulties and you're wondering how to address that in the best way? Please use the opportunity, give us your question, type it into the chat window, and of course we will answer it anonymously. So Martin Jacko, I would like to start with a question that puts your presentation in a nutshell, so to say. Let's imagine the following situation. An Austrian company asks you for legal advice. They want to invest in Slovakia. They want to set up a company here. And now you are in a meeting with the newly appointed Austrian manager of that new company in Slovakia. What are the top 3 recommendations you would give to him or you would give to her on how to safeguard this new investment and how to meet his or her liabilities?
Thank you for this question. Well, definitely it is critical to set up the statutory body of CEOs or all other executive managers to set up properly their competencies, and then definitely to create an environment in which they have to and want to exercise these competencies with professional care and in accordance with the interests of entrepreneur. So big focus to compliance, to controlling mechanisms in order to be sure that all the decision-making processes are transparent and that they are in line with, of course, with the law and with stipulated obligations, as mentioned. Then also to be sure and to set up the proper monitoring of the financial situation of the companies. That means reporting not only on a quarter basis, but not on a yearly basis, but on, let's say, every week, second week, have financial data, and to see also have some prognosis in order to be sure whether the company is not in the situation of indebtedness or bankruptcy or crisis. That would be easier, and to follow the obligations which are set up by the law. And also in the course of creation of the compliance system, also to make sure that, and also in line with the transfer documentation and obligation, to make sure that the activities and transactions between the affiliated persons are done in a proper manner and they are not potentially contestable by whoever. It doesn't have to be in bankruptcy proceedings. It could be also contestable by business partners if they, of course, know about it. So I would say compliance definitely, then financial monitoring, and these would be main recommendations.
Mm-hmm. Thank you so much for those insights. Now, I would also like to ask you, as managing partner of a leading law firm, I think you have a very good sense for the economic situation that we're in at the moment. So in your opinion, how well have businesses in Slovakia survived, managed the pandemic? The recovery we see now, do you think it's solid? And what would you expect from the coming months? Do you expect more bankruptcies to happen soon?
As has been said by Christian earlier, the expectations were worse than it is in real life, and we have seen, of course, increase of bankruptcies in Slovakia. However, it has not been that dramatic. Mm-hmm. On the other hand, it could be also contributed to the fact that there are certain, or the institutes, for instance, of temporary protection of entrepreneurs has been used in massive way, and that could also postpone the real problems of a company because they were protected. So there could be some impact, and there could be even higher increase of the insolvency proceedings in Slovakia. However, I do believe that that restructuring procedure will be again a hot topic, because it's very attractive to go through such a procedures, and that would enable entrepreneurs not to cease their operation. On the other hand, none of us can predict what will be, or how the third wave of COVID will behave and what will be the consequences. definitely it will increase the insolvencies of the companies, but we can only hope that it will be in a low level.
Let's go back for a second to the temporary protection of companies. Until when is this instrument in force, and will it cease to exist for all companies that have applied for it at the same time? And maybe also an operative question, how can one ask for this temporary protection?
The temporary protection is for asking and registering for that or applying is a formal process. There is an application and which needs to be fulfilled. It's electronic. It's done in an electronic way, submitted to electronic mailbox to the court. Must be authorized, and depending on the registered office, it could be submitted to 4 of the courts in Slovakia, either to Trnava, Žilina, Banská Bystrica, and Prešov for the particular regions. There must be several attachments to this application. Definitely the most important, as already said, is the written consent of absolute majority of creditors, which is not older than 30 days, then list of assets, list of liabilities, of course, but also with identification of affiliated creditors and identification of secured creditors, a list of affiliated persons according to the law, and also from perspective of financial documents, there must be an interim financial statement not older than 60 days. It is important to have it prepared in the way that it is successful, because I assume that if somebody is asking for this protection, it needs to be granted immediately or as soon as possible. So, of course, consulting with financial advisors preparing the documents, and also with other consultants necessary is very recommended.
And in your opinion, is this an instrument that has helped Slovakia to manage the pandemic, that has helped the businesses to go through this difficult situation?
I would say that it helped a little bit, of course, because entrepreneurs got possibilities to preserve their operations without being, let's say, attacked immediately with negative consequences. However, we still do not know, and we will, I think, find out in next months whether it did not somehow preserve so-called zombie companies, which anyway were ready for bankruptcy, and it only prolonged their life with secondary impact on the healthy companies. That could be also one of the view. However, I think rather that it helped to the entrepreneurs.
Okay, thank you so much.
But maybe better help would be restructuring or using of the restructuring procedures. However, this would need some changes in the legislation, because we have very, very strict restructuring procedure in Slovakia, and the biggest difference is that there is a 50% satisfaction ratio which needs to be followed, which is most strict I have seen comparing to Austria, comparing to other countries. That would help.
So I have a question here about restructuring. If there's a restructuring plan, the debtor may instruct the bankruptcy clerk to draw up a restructuring opinion to determine whether the conditions for its restructuring are met. Can you describe in more detail the conditions for recommendation of the restructuring?
For sure. So the bankruptcy clerk or bankruptcy administrator may recommend the restructuring if debtor is, it must be a legal entity, which is mentioned in the law and excludes certain legal entities. It must conduct business activities, so it cannot be passive. The debtor's bankruptcy is imminent, or debtor is already bankrupted. And the debtor's financial statements provide accurate view on financial facts, and it is recorded in a proper way in accounting. There must not be or cannot be a period less than 2 years elapsed from the termination of last restructuring. This is very important, so you cannot circulate. And there must be a real chance, evidence chance, to maintain at least a considerable part of operation of debtor's enterprise. So this must be reasonably expected. And the most important is that there is expectation of creditors, unsecured creditors' satisfaction prescribed by the law, the one which I mentioned, 50% plus.
Well, thank you so much for those details, Martin Jacko. I think it is time to conclude the webinar now. I would like to ask Christian Kugel to join us here on the virtual panel briefly. Many thanks to you, Christian. Many thanks to you, Martin Jacko, for these great insights. I think, or I hope, that you were able to help our participants with their everyday challenges. And as said in the beginning, of course, Christian Kugel and Martin Jacko are at your disposal for individual consultation after the webinar. I would like to thank all of you for participating on such a hot early summer morning. I hope that you all have a lunch break ahead of you now and can have some cold lemonade to cool down a little bit. And we look forward to see you again at our next webinar, or maybe next week at the Exploatac 2021. All the best to you and goodbye.
Thank you.
Thank you very much. Goodbye.